We have enough to at least debate, and I think we have a quorum, but we'll proceed and wait till we know that we have to have a certain amount of people to draw that conclusion. We have two bills and several nominees on today's agenda. I'm also going to take a point of personal privilege this morning. I'll do that before Senator Feinstein speaks. Today we have a number of judicial nominees on the agenda, all of whom are on the agenda for the first time, so we will hold them over. The minority has requested that they be held over, so they will be. These would be Mark Bennett, Ninth Circuit, Nancy Brazel, District of Minnesota, also Eric Tostrad from Minnesota, and Robert Summerhays, West District, Louisiana. There are also two U.S. Marshals on today's agenda. We'll vote on them. By the way, we do have enough people here so that those that are being held over, as well as the Marrakesh Treaty implementation that's on the agenda for the first time, so we won't have to deal with those holdovers again. We will vote on two U.S. Marshals if we have a quorum. I want to thank Senators Feinstein, Corker, Menendez, Hatch, Harris, and Leahy for joining as co-sponsors on the Marrakesh Treaty. It's called the Marrakesh Treaty Implementation Act, supported by the National Federation of the Blind, by publishers, by libraries, the entire copyright community, and other public interest stakeholders. The bill has been a truly bipartisan effort, so obviously I want to applaud the ranking member and our co-sponsors for all of their hard work, and I look forward to taking it up when we get back after next week's recess. Today we will also consider the Special Counsel Independence and Integrity Act. This has been introduced by Graham, Coons, Tillis, and Booker. The intent of this bill, and if I'm wrong on this, the sponsors can correct me, is to ensure that special counsels appointed by the Justice Department are only removed for cause. The bill allows a special counsel a way to appeal his or her removal by the Attorney General to a panel of judges. The current bill is a result of months of negotiation between the bill's bipartisan sponsors, who introduced two versions of a special counsel bill in August. This committee held a hearing on those bills in September. At that hearing, we heard from constitutional scholars, some who considered the bill to be constitutional and others who felt it was unconstitutional. To some extent, the constitutionalities of these bills depend upon whether you think the Supreme Court decision in Morrison v. Olson is good law. Justice Scalia dissented in Morrison, and he's justifiably famous and influential, as we all remember, but its reasoning has not yet been adopted by the majority of the Supreme Court, and the majority opinion in Morrison v. Olson was cited with approval by Chief Justice Roberts as recently as 2010. If you believe in the principles of stare decisis, you have to admit that it's at least an open question as to whether Morrison v. Olson is good law and whether these bills are constitutional. You can try to predict what the Supreme Court will do, and they could overturn Morrison, but you might be wrong, and you wouldn't be the first to have made such a mistake. At the hearing, I told the sponsors that I would put their bill on the agenda for the full committee to consider if they could negotiate some compromise language. After they did a few weeks ago, the bill's here because I wanted to keep my commitment. The committee will debate and vote on the bill today. As I've stated before, I have constitutional concerns about this bill. I agree with Justice Scalia that the prosecution of crimes is an executive function, but I also think it's clear, and you folks know my reputation on this point, that Congress has an oversight role to play. Our constitutional system, premised as it is on the principle of separation of power, cannot function unless Congress exercises robust oversight over the executive branch. The Supreme Court has recognized as much, stating that Congress's oversight powers are broad, and that's a word from cases, and that, quote, a legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, end of quote. Special counsel investigations directly involve the legislative work of Congress. Congress wrote the laws that any special counsel investigation is based on, and we can revise those laws. Congress appropriates the funds that make special counsel investigations possible, and Congress may use information gained from its oversight function to conduct hearings or to consider whether to resort to extreme remedies of impeachment. What's more, because special counsel investigations only occur where there is a conflict of interest within the executive branch, special counsel investigations are usually matters of great national concern. And Congress, by exercising its oversight powers, can help the American people to have confidence that these investigations are conducted efficiently and independently. To strengthen the oversight position of this bill, I've proposed text that has been included in the manager's amendment, which I hope the committee will support. This amendment is modeled after current statutory reporting requirements that require the executive branch to issue a report to Congress upon the removal of inspectors general. It also codifies certain Department of Justice regulations governing special counsel. My amendment is supported by the bipartisan sponsors of the bill and requires the Attorney General to provide a report to Congress when a special counsel is appointed or removed and when the investigation of the special counsel concludes. At least in the concluding report, the Attorney General must include information about decisions to expand or contract the scope of the investigation. My amendment is also narrowly tailored so as not to interfere with the progress of an ongoing investigation and to take into account national security and other concerns. Transparency and accountability is very much in the public's interest. The public's business ought to be public, except for maybe national security or privacy. Maybe a couple other things you can think of, but I mentioned those two for sure. The reporting requirements in my amendment will help Congress and the executive branch to do their jobs better. While my constitutional concerns remain, I believe this bill should be considered by the full Senate, and I think my amendment improves it. In addition, if other components of this bill are judged to be unconstitutional, I believe the reporting requirements in my amendment would survive. In some ways, today's vote will say a lot about how each of us view our responsibilities as a senator. We took an oath to protect and defend the Constitution of the United States, but we're neither judges or presidents. We're stewards of the legislative branch. The founders anticipated that we would wield the powers the Constitution affords us with great ambition so that we could effectively check the powers of the other branches. This bill certainly meets that requirement that we take in our oath to the Constitution. It's possible the bill goes too far. and I understand the position of those that have strong constitutional objections who will probably vote against this bill today. But at the very least, if my amendment is adopted, it will require the executive branch to give more information to Congress. And that will enable the Congress to do its job effectively, more effectively, in fact, and to safeguard the interests of the American people. I said I was going to say something of a personal nature, but it says here I'm going to call on you, and then I'll do that.
You can do both.
I'll call on you first. Yeah.
Thank you very much, Mr. Chairman. I want to begin by saying, in my view, this bill is the way this Senate should function. We've had 4 bipartisan senators put it together. We've had the chairman produce a very comprehensive amendment. One side, our side, my side, had problems with parts of that amendment. Everybody went to work and worked it out. And so we have a piece of legislation that I believe will stand the test of time and will also stand the test of scrutiny. I want to commend you for that. You know, you sit in the main seat. It was your amendment, and yet you were willing to make the necessary compromises to produce what I think will be a dominant majority on this committee. I also want to commend Senators Tillis, Coons, Graham, and Booker. They were the 4 that put this together, and as such, they become very important authors of what is an important law that will be passed. The bill before us and the Grassley substitute are the result of these hours of negotiations. I support both. As we know, the Department of Justice regulations say that a special counsel can only be removed for, and I quote, misconduct, dereliction of duty, incapacity, conflict of interest, or for other good cause, end quote. The bill codifies these regulations and provides an extra layer of protection over the special counsel's independence. The bill does this by providing for judicial review. This means that if a special counsel were to be fired for an unjustified political reason, the decision could be challenged in court. I understand some of my colleagues have concerns about the constitutionality of this legislation. Based on what I've learned, I believe that it is constitutional, and I say that as neither a constitutional expert nor even a lawyer. But let me quote Professors Posner and Vladeck, 2 of the witnesses who testified on this very issue at our hearing this past September, who are constitutional experts. Their April 24th letter about this bill explains that, and I quote, they are not only the view that a good cause removal restriction is constitutional, but that this bill would be upheld by the current Supreme Court, end quote. In other words, they find the measure we are considering today clearly lawful. I'd also like to speak about Chairman Grassley's amendment. As I mentioned earlier, this amendment was a result of hours of bipartisan negotiations. And once again, Mr. Chairman, let me thank you for being willing to do so. I know the pride of authorship, and I also know that sometimes it's hard to compromise, but you did that, and this is a better effort because of it. The amendment itself codifies other Justice Department regulations about the special counsel and also requires a report to Congress about the special counsel's investigation once it's over. This reporting requirement is a compromise way to ensure appropriate congressional oversight while also inoculating the special counsel from any political interference from Congress or otherwise. And that is the heart of the matter. Mr. Chairman, I'm happy to support your substitute amendment today, along with both the Democratic and Republican sponsors of the bill. Thank you again for putting this important piece on the agenda and for the bipartisanship you fostered in the way with which you handled it.
Thank you. I'd like to, before Senator Hatch speaks, I'd like to say I'm going to recognize Senator Hatch to speak about what he'd like to speak about now as a point of personal privilege. I'd like to follow him with a point of personal privilege on the same subject, and then we will do the two U.S. attorneys, and then we'll turn to the bill, and then we'll have a substitute amendment, and then we'll have whatever debate you want on the bill or whatever amendments you want to adopt. So, Senator Hatch.
Well, thank you, Mr. Chairman. I'd like to offer a few remarks in honor of Thom Jipping, who spent nearly 15 years as a valued member of my staff and of this committee. We all know Thom. We all care for Thom and love him. He's a fixture on this committee and one of the true experts on judicial nominations. Thom joined my staff in 2003. He'd previously spent 14 years on the grassroots side of things, focusing his work on the federal judiciary and the judicial appointments. And he's put that expertise to great use here on the committee. He knows everything there is to know about nominations. He can quote statistics and history off the top of his head, going back years and decades, really. Thom's also handled a number of important bills on topics ranging from disability law to religious freedom to art exhibitions. He served as the Deputy Staff Director of the Senate Impeachment Trial Committee in 2010 and has drafted hundreds of floor speeches and record statements during his time here. He's really been a wonderful staffer. It's hard to imagine life without him. Thom will be leaving us soon for a think tank where he'll continue to write about and advocate for solutions to our nation's most pressing legal problems. It's hard to imagine life on this committee without Thom. He's done an outstanding job here, and I wish him the very best in his next adventure. Thank you, Mr. Chairman.
And as chairman of the committee, and for somebody that's been around as long as 15 years, whether they're on the Democrat staff or the Republican staff, we all know that we all owe them a thanks for their hard work because staff for Senator Hatch helps people and other senators on this committee with various issues. In this particular case, nominating procedures take up a great deal of the time of this staff. So I want to express thanks, and I'm sure that Senator Hatch wish you weren't going, and I sure hope that you understand that I owe an awful lot to Colin Davis, who's been on my staff for 33 years, and I don't want him to get any ideas of going. So, Thom, we applaud you. Okay, I think we'll do these. We've already held over the names that have to be held over because we had enough people to do that. We have a vast quorum now. Practically everybody's here, and I'm glad that we have that sort of attention to the work of the committee. So en bloc, without objection, and I'll ask for the yeas and nays, we're going to vote on Gregory Forrest, Western District, North Carolina, and Bradley Maxwell, Southern District of Illinois. Those in favor say aye.
Aye.
Those opposed say no. The ayes have it. So Forrest and Maxwell will be reported to the Senate. Now we'll turn to the Special Counsel Independence and Integrity Act. And before we have debate and amendments, I would like to, without objection, call up and adopt the substitute amendment to S-2644. That's Amendment HEN 18497. I hear no objection, so the amendment is before us. The amendment is adopted. So who would seek recognition? Senator Combs.
Thank you, Chairman Grassley. Just want to briefly begin by expressing my great appreciation to you and your staff for working so hard with the bipartisan co-sponsors of this bill. Your commitment to transparency and to oversight, to rule of law, and the institution of the Senate have brought us to this point today. And I'm grateful to Ranking Member Feinstein and her staff for having worked so well to make this possible, to Senator Tillis and Senator Graham, who've been great partners in moving this forward, and to Senators Whitehouse and Blumenthal, who played an important early role in the drafting of the bills that got us here today. I've got much longer comments I'm happy to make after we take this up and vote. I think we should proceed to a vote. I think this is an important day, and I'm grateful that despite concerns that have been expressed by some members, as you laid out in your opening remarks, the current state of the law is that Morrison is still good law. This is an important thing for us to do as a body. This is an important day for us as a committee, and I hope we will move expeditiously to adopt the bill as amended by your important amendment.
Okay, Senator Graham.
Thank you, Mr. Chairman. One, I want to compliment you for allowing this day to come about. We're not judges. Everybody can make their own decision about the constitutionality of this legislation. I feel good about it. There's a case, not exactly on point, but I think covers the subject matter pretty well. We've had constitutional experts say that it would pass muster. The majority leader has said that he doesn't believe there's a need for this bill to move. I'll respect that. But you're the committee chairman, and we've decided the best thing for this committee to do is take up this matter, and we are. Now, in terms of policy, I think it's really good policy that will stand the test of time. What is the special counsel? We used to have a special counsel statute in Congress, and that's lapsed because the special counsel has a lot of power, and people are concerned legitimately that you start at A, that you wind up at Z. Sometimes that can't be avoided, but I can understand people's reluctance to have a prosecutor that can go anywhere and everywhere. But what brought this about was a conflict of interest. As to Attorney General Sessions, it was clear to me that he could not look into any allegations against the Trump campaign about collusion or anything else because he was part of it. To those who think he made a bad decision, I could not disagree with you more. I think as a lawyer, as the Attorney General, he had no other decision. The only thing he could possibly do is recuse himself because you can't investigate the campaign you were part of. As to Mr. Rosenstein, I thought he was a good pick by the President. I asked Attorney General Sessions yesterday, do you have confidence in Mr. Rosenstein? He said yes. He's a hardworking, good man that comes from Maryland, that had the bipartisan support of the Maryland senators and all the Republicans that knew him in Maryland. As far as I'm concerned, I think he's doing a good job. I think he has given Mr. Mueller a charter, and he will report back to us when this is over about did he stay within his charter. That's why I like the Grassley amendment. But I think he's the right guy at the right time. And to the public, what can the President do? We are actually a nation of laws, and this is what this is about to me, the rule of law today, tomorrow, and forever. That's what makes us different from other countries that we hear a lot about. The President cannot personally fire Mr. Mueller. The President can fire the person who appointed Mr. Mueller because that person, Mr. Rosenstein, is a political appointee. And under our laws and tradition, pretty much the President can fire people or political appointees for almost any reason. Can't be a corrupt purpose, but we allow the President to pick and choose his team and to fire people for any reason, virtually, when they're a political appointee. But if you're a civil servant, if you're working for the government and you're not a political appointee, you can be removed, but you have due process protections. What is the special counsel? The special counsel is not appointed by the President. They're appointed by somebody who is a political appointee when there's a conflict of interest. So the reason we have a special counsel is because of conflict of interest regarding the 2016 election. Almost all special counsels are involved in high-profile matters or they wouldn't exist. So what I've tried to do with my colleagues, Senator Tillis, Booker, and Coons, is to find some protections that are consistent with the one case, Morrison versus Olson, that's pretty simple. If a special counsel is fired now, today, or anytime in the future, appointed within the Department of Justice, that special counsel can petition a court to look at whether or not they removed under the regulatory requirements of the Department of Justice for removal. No more than that. You get a chance to petition a court to see if your firing fell within the Department of Justice regulations, which Senator Feinstein has read. Misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause. Now, to me, that's a check and balance that makes sense, because all these cases are going to be controversial where you have a special counsel. He's not a civil servant, or she's not a civil servant in the true sense of the word. It's not a job you're going to do forever, but they're not a political appointee either. So I think the public would be well served to have a judicial check and balance where the special counsel, if they chose, could petition the court to look at their dismissal. And that's all we're asking, and I think that makes perfect sense. And why are we doing this? I think the rule of law in America stood the test of time in this regard. No one's above it. Can't say that in Russia. Can't say that in a lot of places, but you can say it in America. We've had Democratic and Republican presidents challenged for their conduct in office and before office. Nobody in this country is above the law. Now, as to President Trump, I feel very comfortable that he's not going to dismiss Mr. Mueller, because one, he can't, and two, he understands what would happen if you went down that road unless there's a really good reason to fire Mr. Rosenstein. I think all of us on the Republican side have been asked about this continuously, and I have yet to find one Republican who thought it was a good idea to stop this investigation. Where it goes, I don't know. As to Mr. Mueller, he has a reputation of being professional and fair-minded, and I think the rule of law would be well served to allow him to do his job without political interference. Now, he's can be criticized. Mr. Starr was criticized extensively when he was the special prosecutor in the Clinton case, so that's part of the politics of all this. But I would imagine if there had been an effort to remove Mr. Starr, people would have been doing what we're doing on our side. So it's not about Mr. Mueller, it's not about Trump, it's about the rule of law. And it's going to stay in place as robustly as possible as long as I'm here with my colleagues. That's what this is about. It's about a system for today, tomorrow, and forever that makes sure that nobody, even the president, is above scrutiny. The scrutiny can be scrutinized, but there needs to be a check and balance, because when we put somebody in this spot, they're in a political hot seat. That's the nature of the special counsel. And I think we'd be well served as a nation to have a check and balance on that situation. And I'll talk more about why I think we need a second special counsel, but I'll save that for later. I just want my colleagues on the side to know that I join you in preserving the rule of law to make sure that Mr. Mueller and future special counsels have a outlet to ask court review if he thinks something was done untoward them. But there are a lot of aspects of the 2016 election that cry out for a second investigation, and none of you have lifted a finger to do anything about it. And we'll talk about that later.
I'd like to go to consideration of amendments, if there isn't any objection. Who would like to offer an amendment? If nobody wants to offer an amendment, can we go to final passage? Senator Leahy.
I'd like to offer an amendment.
Yes, please proceed.
Are there copies?
Yeah. All right.
Mr. Chairman, as I offer this amendment, I'd like to...
was it filed? Has it been filed?
Yes, it's been filed.
Okay.
Let me pull it up.
Where's his amendment?
Oh.
Where'd it go? Is it this one? No. It's called a Cornyn amendment, apparently.
Okay.
Yeah. It's amendment caption ALB 18495.
We have copies of it. Is that right?
Yes.
Okay.
This is the Cornyn amendment.
Yes.
Is that right?
And I'm offering it.
Okay. Proceed, Senator Leahy.
Okay. We've got a couple of issues here. With respect to the underlying legislation, we're told that if President Trump fires Special Counsel Mueller, that it would spark a constitutional crisis, one that threatens the rule of law in America. Not content to wait, the committee's solution, apparently, is to do the job ourselves by advancing the legislation that we're considering today, legislation to which my amendment responds. Now, there are two constitutional provisions at issue by the underlying legislation and that I try to address through my amendment. The first is Article 2's vesting clause, which provides that the executive power in the United States government shall be vested in the President of the United States. The second is the Appointments Clause, which provides that the officers of the United States must be appointed by the President and confirmed by the Senate. So let's start with the vesting clause for a moment. The text yields a pretty simple, intuitive, but very powerful rule, which is that the President has ultimate authority over all purely executive functions. Therefore, any attempt to restrict that authority vested exclusively in the President is unconstitutional. Both the Graham-Tillis bill and also Chairman Grassley's amendment violate this command by infringing on the quintessentially executive power to conduct criminal investigations and to prosecute or to make decisions as to whether to prosecute. Now, the primary transgression in these bills is that they prohibit the executive from firing a special counsel except for cause. As a matter of black-letter law, the applicable cases, Myers v. United States and Humphrey's executor, establish that the President has authority to fire officials who exercise purely executive functions, while at the same time Congress can limit the President's removal power only with respect to officers who exercise quasi-legislative or quasi-judicial authority. The exercise of prosecutorial authority is the canonical, quintessential executive function, and restricting the use of that power, including by limiting the President's ability to terminate someone exercising that power, simply is not permitted and is fundamentally at odds with Article 2 of the Constitution. As a matter of first principles, the vesting clause ensures that the President is ultimately accountable to the voters for the conduct of the executive branch. This theory falls apart if the President is powerless to control the executive branch. Yet the entire purpose of this legislation that we're considering today is to limit the President's power to control the special counsel by removing the power to remove the special counsel. Now, while it might be tempting to regard this failure to comply with the separation of powers mandated by the Constitution as abstract, academic, victimless, it almost certainly will have a significant impact on liberty. As then Attorney General Robert Jackson wrote back in 1940, before he went on to the Supreme Court, he said, quote, "The prosecutor has more control over life, liberty, and reputation than any other person in America." That's even more true when the prosecutor cannot be fired for exercising that same power unwisely. Chairman Grassley's amendment has some additional defects. Among other things, it requires the Attorney General to appoint a special counsel in certain circumstances and announces that the special counsel is not, in fact, subject to the day-to-day supervision by the Attorney General of the United States. Nor is this person subject to the acting Attorney General of the United States, further removing the special counsel from the normal chain of command within the executive branch, conferred upon the President by the Appointments Clause and by the Vesting Clause. I understand that these provisions codify existing Department of Justice regulations, but there is a very meaningful difference between internal regulations, procedures adopted by an executive branch agency, like the Department of Justice, and statutes that we put in place that purport to tie the hands of the executive within the executive branch of government. It's very difficult. It's a very different thing, what we're trying to do here, which is for Congress to mandate how it is that the executive branch discharges these functions. But perhaps the most remarkable and troubling aspects of Chairman Grassley's legislation concern the reporting requirements to Congress. The Grassley Amendment requires the special counsel to submit a report outlining the investigation's findings and explaining the decision to prosecute or any decision not to prosecute. This is an unexplained departure from the Department of Justice's existing regulations, which require the special counsel to provide the Attorney General with a similar confidential report at the conclusion of the investigation. At a practical level, this bill provides no way to enforce this requirement, and I believe that were this legislation to become law, the executive branch would not, in fact, comply with those provisions in any event, because they're manifestly dangerous. They're reckless. Imagine that the special counsel, even only for a short period of time, believes that an individual may have committed a crime and ultimately concludes that the person should not be charged. This legislation would require the special counsel to reveal to Congress and effectively to the entire world the identities of targets of an investigation. I thought there was a consensus in the committee that James Comey should not have publicly announced that the FBI would not charge anyone in connection with the Clinton email investigation. At least that was my sense last time we discussed this within the committee. And yet this legislation would be hard-pressed to find a better example of how ignoring the separation of powers can end up affecting the lives of the American people. So not an abstract injury to the Constitution we're talking about. The Supreme Court, of course, upheld the independent counsel statute in Morrison v. Olson, and that decision has never formally been overruled. But most lawyers do not regard Morrison as good law, and the Supreme Court would likely not reach the same conclusion today. Just as the Supreme Court likely would not reach the same decision about a lot of other things that have been decided in the past. Korematsu versus United States is a good example of a case that was decided wrongly. It's never been expressly overruled. And yet, I am certain, in fact, that were we to consider a similar policy today, every one of us would stand forward and say this is unconstitutional. Something can be unconstitutional even if the Supreme Court in the past has wrongly designated it as constitutionally permissible. In Free Enterprise Fund versus Public Company Accounting Oversight Board, the Supreme Court reaffirmed that restrictions on the President's Article II authority were permitted only in the context of independent agencies that do not exercise purely executive functions and with respect to the civil service. Importantly, Special Counsel Mueller doesn't fall into either of these categories. There's not even an argument that he's got civil service protection, nor is there an argument that he fits into one of these categories of quasi-legislative or quasi-judicial authorities. The dissenters in Free Enterprise Fund did not disagree with that premise, and there are strong reasons to think that both Justice Kagan and Justice Gorsuch, neither of whom were on the court when Free Enterprise Fund was decided, would have voted with Justice Scalia in his classic dissent in Morrison v. Olson. Justice Kagan has herself said that Justice Scalia's masterful dissent in Morrison was, quote, one of the greatest dissents ever written, and every year it gets better. This is based on the understanding that increasingly people have realized on both sides of the ideological spectrum, on both sides of the political continuum, that Justice Scalia was right in his dissent in Morrison v. Olson. In fact, most legal scholars and commentators across that same spectrum now think that Morrison is not good law. Professor Akhil Amar has testified as much in front of this very committee, and he's joined by a lot of other professors who don't exactly align with Republicans on many issues. The Appointments Clause provides an independent reason to question these bills. In Edmonds versus United States, a unanimous Supreme Court concluded that inferior officers who need to be presidentially appointed and then need to be confirmed by the Senate are officers whose work is directed and supervised at some level by principal officers. If these bills prevent the Attorney General from firing a special counsel because the special counsel has acted unjustly or perhaps unwisely, then it's difficult to contend that the special counsel's work is directed and supervised by a principal officer in any meaningful sense. The power to remove is the power to control. And if you truly are supervising someone, you have the ability to stop them. You have the ability to remove them from the position they occupy if they exercise that power wrongly. Now, I understand the demands of politics, but that's no excuse. Every member of the Senate swears an oath to uphold and protect and defend the Constitution of the United States. And that oath means that we're duty-bound to seriously, personally assess the constitutionality of legislation we consider and to vote against legislation we deem unconstitutional. Merely advancing this legislation from committee, unfortunately, shows that the political demands of the Constitution may somehow trump the Constitution. That's especially unfortunate because there is a better alternative. The amendment that I'm introducing sends a clear signal that the President should not fire Mueller and does so without inflicting damage to the Constitution. And it acknowledges these points that I've made with regard to the President's power under the Appointment Clause and under the Vesting Clause. And with that, Mr. Chairman, I offer up this amendment.
Before I call on Senator Tillis, I hope that we can kind of maybe limit debate to a couple of points of view on each side of an amendment because we have 6 or 7 amendments filed. Senator Tillis.
Thank you, Mr. Chairman. You know, for the last 3 years I've been on this committee as a non-attorney. Every once in a while I wonder whether or not I wished I'd gone to law school and become an attorney. And Senator Lee's comments right there make me glad that I didn't, because I don't think there's any way I could match him on the arguments. In fact, it sounds like the arguments that may go before the court when equal numbers of people are on either side of the issue. Back when I was Speaker of the House, when we would pass certain bills to try and assert legislative authority versus the executive branch, I would have meetings like these in my office where it wasn't clearly decided. I never allowed a bill to advance where I think it was clearly unconstitutional or inconsistent with the state constitution. But I think this is an issue that's going to be debated. It may even open up what Senator Lee asserts is a bad law decided by the Supreme Court. But let me tell you the main reason why I've got a problem with this amendment, aside from the fact that it guts the underlying bill that we hope to get passed today, is this sense of the Senate makes this about Mueller. I didn't go about this bill because of Mueller. I became educated on the potential risk as a result of the activities of last August. That's why I decided to file the bill. But I'm trying to create law that has enduring value. It doesn't reference the special counsel or special counsel Mueller. What it tries to do is assert this institution's authority. I mean, we're members of the Senate. We're stewards of the Senate. We're stewards of the Congress. We should always be looking for ways to assert our authority. And every once in a while, if we go outside of the bounds, then the Supreme Court will check that. But I don't think it's our job to be SCOTUS. I think it's our job to figure out ways in which we can actually have some control, increase transparency, and accountability. Our bill isn't about Mueller. Now, I would fully expect that there are going to be some people that are motivated primarily because of this special counsel. But I'm looking forward to 12 years from now, 16 years from now, when maybe we have a similar circumstance and this bill becomes law, and we're going to have had some say in exactly how that special counsel is handled. And for that reason, I'll be voting against the amendment.
Can we vote on the amendment? Senator Lee.
Respond very briefly.
Senator Lee.
Okay, first of all, to say that this legislation is not about Mueller goes against pretty much everything that I've ever heard anyone say about it, ever. And so let's not pretend that it's not. My amendment does 2 simple things. It just recognizes that it's the sense of the Senate, that the Senate should not be resurrecting unconstitutional barriers, unconstitutional provisions that interfere with the separation of powers, and that Robert Mueller should be able to finish his investigation in a timely manner. Again, there is no argument here that he is a protected civil servant. There is no argument here that he is another type of officer wielding quasi-legislative or quasi-judicial powers. Therefore, he's got to either be a superior officer or an inferior officer who serves subject to the supervision of a superior officer. That is within the President's domain. That's why I filed this amendment, and I encourage my colleagues to vote for it.
After Senator Hatch, I hope we can vote. Go ahead, Senator Hatch.
Okay. I'd first like to say that I appreciate your work and the work of other members of this committee on this legislation. This is a thorny issue, and I recognize we're trying to do the right thing here. From the earliest days of the Mueller investigation, I've said, can we get that to work? Put a quarter in it. Try and talk louder.
It surely won't be Graham's quarter, I'll tell you that.
That's good.
At least I know what one looks like.
Okay, it's working now. Yeah, I'm familiar with Senator Graham, too.
Put a quarter in him.
From the earliest days of the Mueller investigation, I've said the investigation should be allowed to run its course. I think that's in the best interest of both the President and the country. Firing Mueller would cause a firestorm and bring the administration's agenda to a halt. It could even result in impeachment. I think we're right to convey a strong message to the President that he should not fire Robert Mueller. I've said that many times, and I've joined my colleagues today in co-sponsoring this resolution that says exactly that. But in seeking to protect Mueller and to impress upon the President the crucial importance of allowing the investigation to run its course, it's important that we not overstep our constitutional authority. I applaud the impulse behind today's special counsel legislation, but I cannot support it because I believe the bill is unconstitutional. Prosecution is a core executive function, perhaps the core executive function, and the Constitution commits that function to the executive branch. Efforts by Congress to constrain or control executive branch authority over prosecution transgress the separation of powers and bring Congress into direct conflict with the Constitution. We've been down this road before. Congress passed the independent counsel statute in response to the excesses of Watergate, and it was a mistake. Justice Scalia's famous dissent in Morrison versus Olson laid out the litany of reasons why that law was unconstitutional. Justice Scalia's central insight that prosecution is a core executive function and that congressionally created restraints sap the political accountability that must be present in all prosecutions was ultimately vindicated. Congress allowed the independent counsel statute to expire in a bipartisan fashion. Morrison v. Olson has not been overturned, but there is widespread agreement today that it was wrongly decided. I, for one, think Justice Scalia was right, and that is why I do not find compelling the arguments that the special counsel bill is constitutional, because it is consistent with Morrison. Morrison was wrongly decided, and Congress should not compound the court's error in Morrison by crafting new constraints that similarly transgress the separation of powers. For-cause removal requirements for officers who exercise purely executive power, such as prosecutors, are constitutionally suspect. So, too, are judicial review provisions that allow courts to second-guess the reasons for removing such officers and even to reinstate such officers if the court so decides. To be sure, the President should not fire Robert Mueller, and it is entirely appropriate for Congress to formally convey its views on this subject to the President. But it's never appropriate for Congress to contravene the Constitution's separation of powers. You cannot protect the rule of law by violating the supreme law of the land. And for that reason, I will oppose today's bill. But I ask unanimous consent to enter into the record a Wall Street Journal op-ed that I authored that further expresses my views on this subject, Mr. Chairman.
Without objection, it will be entered. Senator Coons.
Great. Thank you, Mr. Chairman. I have lengthy remarks by way of debate about whether or not Morrison is good law, whether or not the description offered about the Constitution's appointment power.
Can you put that in the record?
I very much look forward to putting it in the record. I will simply say one sentence, that the D.C. Circuit in a recent en banc decision said that Morrison, and I quote, remains valid and binding precedent. I also think it's important to remember we're not dealing with the independent counsel statute. This is a much more modest statute. And were we to adopt the resolution offered, it would remove and gut the carefully crafted amendment offered by the chairman that includes provisions on transparency and oversight. I urge all my colleagues to vote against this amendment.
Clerk will call the roll.
Mr. Chairman, I just ask unanimous
Okay,
consent.
Senator Hatch, and then I see Senator Booker. Senator Sasse and then Senator Booker.
Just unanimous consent to put the Scalia opinion in Morrison in the record. I think that it would be disastrous for the nation to fire Mueller, and it would be politically suicidal for the president. And yet, the Scalia opinion, many of us feel that we're bound by it. I think this bill is unconstitutional, but protecting Mueller is a great instinct, and it would be politically disastrous for the president to act. But if I could ask unanimous consent to put the...
Without objection, so ordered. Senator Booker.
First of all, I just want to correct for the record, I've consulted with Senator Coons, and he urges his colleagues to vote no on the... I'm so sorry to my ranking member. I consulted with Senator Coons, and he intended to say that he urges his colleagues to vote no on the amendment. Okay. I know he respects Senator Lee, but he was not persuaded by the arguments that he presented. I do want to just reiterate what my colleague said. Senator Lee has had much more experience practicing law than I have, and I went to a school of philosophy, the Yale Law School, not quite the great school that he attended. But I do want to say that the dissent that has been talked, if you spend some time with the dissent and actually read it, it has to do with the independent counsel statute. It talks about many different points of intrusion, only one of which applies here. And as a guy who's watched the history of our Supreme Court for a long time, I agree with you. Like, I would not want the Plessy decision to hold. There's times that the Supreme Court overturns decisions. But the concept of stare decisis is very, very important. And this is clearly a case where subsequent to that decision, this court and other courts have upheld the majority opinion, 7-1 in Morrison. This is a very distinct rule that is not covered by the full intent of that dissent. And I encourage, and I'm grateful for Senator Sasse asking for it actually put in the record. I hope my colleagues will read that dissent. It does not apply fully here except for one point, which is the idea of the unitary executive. But even that, I ask people to consider that the presidential power is not extreme. And unless we throw out all the for-cause elements of their ability to fire and remove, especially inferior offices, this bill under that pretense, this amendment under that pretense is to me constitutionally valid. And as you said quite eloquently, sir, in your opening remarks, let's do our job and let's allow the Supreme Court to do theirs. I've been spending a lot of time since I was privileged enough to come on this committee to reread the Federalist Papers, to focus on our founders and their intent. And what's been stunning to me is how much we complain about the partisanship of our era. The partisanship at our founders' era, especially in the early days of our republic, was extreme. To my knowledge, we've had no duels, we've had no canings here in this body. And this has been, I heard one of my colleagues whisper, not yet. But I just have to say this has been one of the more privileged moments I've had as a United States Senator. Chairman, your team has been extraordinary in the way they have worked with the four sponsors of this legislation. It is a moment in time where, like our founders at their best, we pull ourselves out of historical the exegesis of this moment, and we begin to look at the long frame of history. I really want to reemphasize the admonition that Senator Tillis gave this whole body earlier, and I took it as very pointed advice, that this should not be a politicized moment. This is not about one president in this point in time. Looking into the future, it is really important that should a president of the United States or their associates be under investigation by the special counsel, that there are reasonable checks and balances on the power of the president to undermine the rule of law and such an investigation. I really believe this can be a point where this committee, like our founders did at times, pulling themselves out of a point of the exigencies and the politics of the moment and looking at the longer story of our country. We could do something here today that could provide common sense, pragmatic checks and balances to executive authority at a time that I've watched in Congress, especially on things like the authorization to use military force, slip away from the Article I branch of government to the Article II branch. It is my hope that my colleagues understand that this is a very modest step, not only at a time right now where some of us might believe it may be needed in terms of sending a signal to the President, but at a time that we look into the future and can virtually imagine a time when this would be needed. I want to conclude with this point. This has been on both sides of the aisle in this committee, where staffs, where principals have come together and worked in a coordinated fashion to produce something that I think is not just needed in the moment, needed in the long term, but I do believe the thoughtfulness and way we've crafted this narrowly will withstand constitutional muster. But that's not our job. Our job is to do the best we can in this moment in crafting legislation. And if this has a Supreme Court challenge, so be it. Thank you.
The clerk will call the roll on the Lee amendment.
Mr. Hatch.
Aye.
Mr. Graham.
No.
Mr. Cornyn.
Aye.
Mr. Lee.
Aye.
Mr. Cruz.
No.
Mr. Sasse.
Aye.
Mr. Flake.
No.
Mr. Crapo.
Aye.
Mr. Tillis.
No.
Mr. Kennedy.
Aye.
Mrs. Feinstein.
No.
Mr. Leahy.
No.
Mr. Durbin.
No.
Mr. Whitehouse.
No.
Ms. Klobuchar.
No.
Mr. Coons.
No.
Mr. Blumenthal.
No.
Ms. Hirono.
No.
Mr. Booker.
No.
Ms. Harris.
No.
Mr. Chairman.
No.
Mr. Chairman, the votes are 6 yeas, 15 nays.
Okay, by that vote just announced, the Lee amendment is defeated. Now we'll go to final passage. Call the roll.
Mr. President.
Oh, just a minute. By the way, before you speak, I will.
Chairman.
I will.
Whatever.
If we do vote, just soon as Senator Cornyn's done, if we do vote on it, I'll stay in session so people can speak as long as they want to. Senator Cornyn.
Excuse me, Mr. Chairman. It's topics like this that make me glad I'm on the Senate Judiciary Committee. I think this is really the important role that this committee plays, and while I disagree with the remedy prescribed, I do appreciate the chairman bringing this up and letting the committee debate it and vote on it. This is an important topic. I join all my colleagues on the committee and counsel be allowed to complete his investigation and do so in a timely fashion. I believe that we are all in agreement on that. Director Mueller should be allowed to finish his work. But that's not what we are considering here today, in my view. I agree with the eloquent arguments made by our colleagues Senator Lee and Senator Hatch as regards the constitutionality. I agree with Senator Lee. We take an oath to uphold and defend the Constitution, no different from the judiciary. And Marbury versus Madison did not erase our independent obligation to assess the constitutionality of legislation ourselves. So that's the first reason I will vote against the legislation, because it's unconstitutional. Secondly, I believe it's unnecessary. The President is not going to fire Director Mueller, I believe, because the repercussions of doing so would be disastrous for his presidency and for the country. Third, this bill will not be taken up on the Senate floor. Fourth, the House will not pass it. Fifth, the President will not sign it, nor should he. I think it's instructive to go back and look, as I have and perhaps many others have, at the Congressional Research Service history of the independent counsel statutes and why we have ended up with a special counsel that's provided for under Department of Justice rules. I know others have talked about the Supreme Court precedent, but I think it's just as telling to look at why there was a bipartisan consensus in 1999 to let the independent counsel provision expire. Senator Durbin, I know at the time, made some comments, and I agree with him, that it was wise to let it expire because of the excesses of the Clinton impeachment investigation, the Whitewater investigation. Others on this side felt like the Iran-Contra independent counsel ran rogue and extended way too far beyond the authority under which the independent counsel was created in the first place. And I fear that we are, if we were to pass this legislation and if it were somehow magically to become law, we would be resurrecting many of these problems with the independent counsel provision that Democrats and Republicans alike in 1999 agreed should become, should expire. So, I think we do have an independent responsibility to assess the constitutionality of the statute. This bill will not be taken up on the Senate floor. The House will not pass it. The President will not sign it. And so, for that reason, I think the appropriate remedy was to do what Senator Leahy offered, which was to offer a resolution expressing the sense of the Senate. But I cannot in good conscience sacrifice what Justice Scalia stated was the single greatest and most important guarantor of our liberties in our Republican government. And by that I mean the separation of powers. Because it happens to be politically expedient. I'm not judging the motivation of my colleagues. I just can't do it believing as I do that it is unconstitutional. And at the same time, I just want to reiterate what we all believe, that Director Mueller should be allowed to complete his work in due course. Thank you, Mr. Chairman.
Okay. Can we, you will speak after the vote, Senator Leahy. Okay, the clerk will call the roll on final passage.
Mr. Hatch?
No.
Mr. Graham?
Aye.
Mr. Cornyn?
No?
Mr. Lee?
No.
Mr. Cruz?
No.
Mr. Sasse?
No.
Mr. Flake?
Aye.
Mr. Crapo?
No.
Mr. Tillis?
Aye.
Mr. Kennedy?
No.
Mrs. Feinstein?
Aye.
Mr. Leahy?
Aye.
Mr. Durbin?
Aye.
Mr. Whitehouse?
Aye.
Ms. Klobuchar? Aye. Mr. Coons?
Aye.
Mr. Blumenthal?
Aye.
Ms. Hirono? Mr. Booker?
Aye.
Ms. Harris? Aye. Mr. Chairman?
Aye.
Mr. Chairman, the votes are 14 yeas, 7 nays.
Okay. 2644 will be reported to the floor. I'll call on Senator Leahy. I'll go back and forth. Let me call on Leahy and then you and then Durbin. And is there any other Republican wants to speak? Okay, then we'll do it this.
Okay.
Yeah.
Thank you, Mr. Chairman. I will put my whole statement on the record, if I might. But as the most senior member of the Senate, the Dean of the Senate, I feel obligated to share my perspective today. I'm a lawyer. I'm a former prosecutor, as many are in this, on this committee. But during my 4 decades in the Senate, both Republican and Democratic administrations, I have never before seen career, non-political law enforcement officials so relentlessly attacked by our government. I've never before seen critical national security investigations so blatantly politicized. Never in 44 years. And frankly, I've never been so concerned that the walls protecting the independence and the integrity of our law enforcement institutions are at risk of crumbling. Remember, our nonpartisan law enforcement institutions are a hallmark of our republic. It sets us apart from so many other nations around the world. America's democracy endures because we empower these institutions to uphold the rule of law and pursue justice with no regard to who is in power. We remain a nation of laws and not of people. And I think when these institutions are under attack as they are today, this committee, probably more than any other committee in the Senate, has to act. So I think, the special counsel's ability to finish his job can't be subject to the latest tweet or hair-trigger impulse of the president. I'm hopeful that the strong bipartisan stand we're taking today may well prevent us from waking up to a tweet storm that sends us careening toward a constitutional crisis. And I don't say that lightly. I've thought about this. I've sat in my farmhouse in Vermont thinking about it. I've sat in these committee hearings. I was at an Appropriations Committee meeting with the Attorney General yesterday. I would say, Mr. Chairman, this legislation represents the best of the Senate. Members worked in good faith on a difficult issue. They sought common ground, both Republicans and Democrats, for the good of the nation. And I want to express my appreciation to the bill sponsors, to you, Mr. Chairman, and to Senator Feinstein for working together. Now, our work is not done. We have a strong bipartisan vote today. I hope the majority leader will work with us to bring this vote on the floor. We have to understand, we're here for a time. Other senators will replace us. The Constitution continues. Our country continues. The checks and balances in our country continue. We have to stand up as members on that. And when something is not done right, we have to say so. So, Chairman, I'll put my whole statement on the record, but in 44 years in the Senate, I've never been this concerned. Thank you very much.
Thank you, Senator Graham, and then Senator Durbin.
Thank you to my colleagues, Senator Tillis,
back and forth.
Booker, and Coons. I really enjoyed working with you, trying to find a way forward for the country. Special counsels by nature are unique, and they should be, and this came about as a conflict. There is no proof of collusion between the Trump campaign and the Russians that I've seen, but the point is that the campaign is under investigation. Attorney General Sessions made the right call to say, I can't be part of investigating the Trump campaign because I was a key member of it. I think Mr. Rosenstein is doing a good job, and hopefully he and Mr. Mueller will do this in a professional manner, and I see no evidence they're doing anything other than that. We'll get an answer to all these questions pretty soon. But one thing I do want to just build on what Senator Leahy said. My motivation for this is to make sure that we're a nation of laws, that no moment in time can overcome the rule of law, and that we'll have special counsel protections in perpetuity, because I can see where in the future this may arise. There'll be a conflict, and judicial review of for a cause removal is probably good for the country. We're not saying you can't fire somebody. We're saying somebody's going to look over your shoulder in these hotly contested political environments. But Senator Leahy said something I want to build on. Impartial law enforcement is one of the key concepts of the rule of law. To my colleagues on the other side, where have you been? Have you not read what's going on regarding the lead investigator, Mr. Strzok, of the Clinton email investigation, and Ms. Page? You can have all the political views you want as a law enforcement officer, but you can't put your thumb on the scale. You can't take your biases and put your thumb on the scale. If you don't like one candidate, fine, but if you're investigating the other, just do it professionally. This is an email, August 15th, 2016. I want to believe that the path you threw out for consideration in Andy's office, and who is Andy, by the way, that there's no way he gets elected, talking about Trump, but I'm afraid we can't take that risk. It's like an insurance policy in the unlikely event you die before you're 40. This is the head investigator talking about investigating the Clinton email scandal, talking to a member girlfriend in the Department of Justice. I think we're best off. There's no way he gets elected, but I'm afraid we can't take that risk. Can you imagine the shoe were on the other foot? You had an FBI agent and a lawyer in the Department of Justice talking all the time about how bad the Democratic candidate was, and we need to do what we can to help the Republican candidate. This is stunning. He's been dismissed by Mr. Mueller, but I am not going to stop, because you can say a lot of things about the Clinton email investigation. You can't say that the people in charge of it were impartial. Now, the private server was taken out and beaten with a hammer. It was scrubbed with chemicals. They defied a court order to turn over the server to the FBI. The bottom line here is that when you look into what happened to the Clinton email investigation, it was anything but impartial. Mr. McCabe has been dismissed based on a recommendation by the Inspector General because he was leaking information contrary to the Department of Justice rules about the Clinton Foundation. The FISA warrant against Mr. Carter Page, the dossier that was used by the court, provided by the FBI, was compiled by a foreign agent, Mr. Christopher Steele, who was on the payroll of Fusion GPS, who was being paid by the Democratic National Committee and the Clinton campaign to do opposition research against candidate Trump. They paid him $168,000. He went to Russia to compile a dossier. Where do you think he got the information from in Russia? How hard would it be for Russian intelligence services to play him like a fiddle? The dossier was compiled, and at the time it was submitted to the court, there was zero effort to validate it. None. Salacious allegations against candidate Trump, now President Trump. What would happen if the shoe were on the other foot? That if the Republican Party had paid a private organization to hire a foreign agent to go over to Russia to investigate a Democrat candidate, it was used by the Justice Department, given to the courts without any validation. It'd be front page news everywhere. If you care about the rule of law, you ought to care about this. Mr. Page was being looked at by the FBI, but the warrant applications, the main reason they gave the warrant is because Mr. Steele had been used in the past in a reliable fashion, and the dossier was the supporting documentation the court relied upon. If you don't believe me, look into the file. So if you care anything about the rule of law, wouldn't you want some correction of this problem? Somebody to be held accountable? And let the court know in the future, oh, by the way, this document is being prepared by somebody who hates the candidate they're looking at, and you need to look at what Mr. Steele's attitude about this was. He told Mr. Orr that he's desperate that Trump not get elected. He told the FBI when he was an informant for them, or a source, that he was not using the dossier for political purposes. He had not given it to the media. He was lying. He had given the dossier to the media, contrary to what he said to the FBI, because he's being sued in British court for defamation, and in the court filing, he admits to giving it to the press while working for the FBI. Now, in October, the FBI discovered this, and when they asked him, why did you do it? And here's what he said to Mr. Orr. Well, when y'all reopened the Clinton investigation, I thought that was really unfair, and I had to do it. Political as you can possibly be, motivated for political reasons, gave the dossier out, according to his own words, because he didn't like what the FBI did about reopening the Clinton email investigation. That should bother everybody in this country. Mr. Orr, his number one contact, who is he? He's the fourth guy in the FBI, in the Department of Justice. His wife worked for Fusion GPS, for God's sake. His wife worked with Mr. Steele. Can you imagine how it would be on the other side? So, I am glad we did this today for the special counsel. I stand with my colleagues on the other side, on this side, that President Trump somehow tried to fire Mr. Rosenstein or get rid of Mueller It would blow up in his face. It'd be the worst decision of his presidency. It'd create a crisis for this country. We don't need that. Let's move forward in a professional way. But I promise you this, that if you believe that law enforcement should be impartial, then you should care about what I'm saying. If you believe that the fourth person in the Department of Justice should tell everybody his wife works for a research fund, a firm paid by the Democratic Party and the Democratic nominee, and that the person they hired hated candidate Trump, went to Russia to get a bunch of garbage, and the court used all that without being informed, then that goes to the heart of the rule of law also. And I cannot believe we don't have a special counsel for this. This, to me, undermines, as much as anything else, the way the system should work. Bias everywhere, wanting to get a result, damn the process. Thank you.
Senator Durbin.
Mr. Chairman, let me first thank you and your staff, as well as Senator Feinstein as our ranking member, and the 4 members who were party to the negotiation that led to our vote today. It was really a demonstration of not only good faith and talent, but a determination to come up with a bipartisan work product. I thank you for that, and I thank you for your leadership in bringing us to this moment. I'm not going to respond directly to my friend Senator Graham. I will agree with the outset of his comments of my respect and confidence in Bob Mueller. This committee knows him well. As former head of the FBI, who in one of the rare occasions had his term extended, we had a chance to know him, to work with him, and to develop a healthy respect for this man's professional ability. I would like to say 2 or 3 comments. Number one, I think it is good for us to believe and to focus on our work product being able to stand the test of time and to be able to work not only under current circumstances but future as well. We cannot, should not ignore the elephant in the room, literally and figuratively. We are dealing with a situation that Senator Leahy alluded to, where a president has tried to undermine the integrity and our confidence in our law enforcement agencies. What we are trying to do is to protect Mr. Mueller and his investigation, to make sure that it is completed in a professional way. It is that is the reason that brings us to this moment. Senators on the other side can say this is not about Bob Mueller, but let's be honest about it. It is. It is. We've come together because of our concern about his completing this investigation. Let me say, Senator Lee left, and I just want to salute him in his departure here. Even when I disagree with him, he makes a thoughtful presentation of constitutional principles. In this particular case, though, I think that many in this committee are so smitten with the former late Chief Justice that they look for Scalia decisis instead of stare decisis. We have an existing decision by the Supreme Court under Morrison that has not been overturned. It may be controversial, it may be debated, and maybe Justice Scalia is right. History may show that. But it is the controlling law for this moment, and that Morrison decision, I think, gives us sound basis for what we achieve today. I want to address the point made by Senator Cornyn, which has come up repeatedly. How many times have we heard in this committee, well, do what you wish in the Senate Judiciary Committee, but former Senator Sessions may not approve. Mr. Chairman, I think you spoke out on that issue yourself, and I'm glad you did, because the Attorney General's approval of what we're doing has nothing to do with our responsibility. We have a responsibility to the Constitution and to this committee to deal with the issues in a thoughtful way, regardless of the opinion of the Attorney General. And let me also add, a 14-7 vote out of the Senate Judiciary Committee, which we just had on this measure, I hope will be noted by the Republican majority leader. This is an issue that should come to the floor. We have another issue that we share that should come to the floor. It isn't as if we are overwhelmed with work on the floor of the Senate. There is a motion floating around about leasing out the Senate chamber for events, wedding receptions and memorial services. We use it so seldom. Why can't we take up an issue like this when we return that is timely and important and debate it on the floor? And let's have a vote. It would be almost like the United States Senate if we had something like that. And I hope that Senator McConnell will consider that possibility. And finally, let me say this. I've said a couple things in the past about the Senate Judiciary Committee, its place in history, the reason why I respect this appointment so much. This is a day that I think pays tribute to that history and is part of it and will be remembered. And I hope that we don't stop with this. There is more to be done in relation to changing our laws to penalize those who would try to invade the American electoral democratic process, this is the place, this is the venue, this is the only committee with jurisdiction to do it. We proved today that we can rise to the occasion. Mr. Chairman, I hope we do it again.
Thank you, Senator Durbin. Now, Senator Whitehouse.
Thank you, Chairman. I'll be very brief. I first wanted to say that I was one of the original co-authors, co-sponsors of one of the two measures that have been combined here. And when the decision was made to go forward on a 2-by-2 basis, I stepped back, but I kept a very close eye on the negotiations that continued forward. And I just want to join other colleagues in thanking Senator Tillis, Senator Graham, Senator Booker, and Senator Coons for the good work that they and their staffs did, and echo the comments about the extraordinarily productive and helpful role that you and your staff played in bringing a slightly variegated issue, perhaps I can say that without dispute, into a form where we got a strong bipartisan vote today. I appreciate that very, very much. I do wish to make the point on my own behalf that I don't think we need to assert that Morrison v. Olson must stand as it is in order to defend this statute. I think that this statute would stand on its own merits, even if the Supreme Court were to considerably reconsider Morrison v. Olson, in the same way that we allow civil service protection, which includes judicial review of unlawful and improper firings, for the public purpose of protecting against over-partisanship and the spoils system in the executive branch. There's every reason to believe that judicial review of a firing in this case would withstand constitutional scrutiny on its own muster, because there is a similar public policy involved. You don't get special counsel unless you have conflicts of interest. And to have the public assured and to have the Constitution operate in such a way that we can guarantee that the rule of law exceeds conflict of interest, that it trumps conflict of interest, I think is an important principle that the court would uphold if this law were to come before it. The last thing that I will say is that I am very pleased that the chairman's amendment has protected a principle that I consider sacrosanct, which is that during the conduct of an ongoing investigation, the investigators and the prosecutors never be put under any ongoing obligation to report in or otherwise make disclosures to Congress. In Rhode Island, I was the Attorney General of my state. It's a state where we don't have DAs. There are 3 states where the Attorney General does everything, and Rhode Island is one of them. So I've overseen an awful lot of criminal practice, and the notion that I should be obliged to check in with the Rhode Island General Assembly in an ongoing criminal investigation makes my head want to explode. That is, I think, a truly intolerable intrusion on prosecutorial independence and investigative secrecy, which are essential for the enforcement of our laws. It is no different coming here to the federal level for a U.S. attorney to be put under some stricture that in the course of an ongoing criminal investigation, he or she should be obliged to check in with Congress and update them on the status of the investigation is equally head-bursting a theory. So I'm glad we have steered well clear of that. That would have been to step into a very, very dangerous and unprecedented area with huge damaging repercussions. So I particularly appreciate all of the negotiators having steered us clear of that particular bear trap. So with that, I conclude my remarks, but with great appreciation again, Mr. Chairman, to you and to your staff.
Okay. Senator Klobuchar.
Thank you very much, Mr. Chairman. I like that the segue from Senator Whitehouse's fine remarks was the word bear traps, since we actually have bears in northern Minnesota. I don't know. Okay, good. But I just wanted to...
For the record, we have bears in Rhode Island.
Okay, I did not know that. That's very good. Okay, good. Okay, if anyone didn't hear that, this was a tribute to the Chicago Bears by Senator Durbin. Okay. To be serious for one moment, I really do want to thank you, Mr. Chairman, for your leadership, and Senator Feinstein, the way you worked together on this. Your experience mattered here, and your devotion to this committee and the institution of the Senate, which in your words, Mr. Chairman, is a check and balance, as we should be in the legislative branch, on unfettered executive power. And I think it really shone through the way you were able to work with the authors here on a bipartisan basis with Senator Coons and Senator Booker, Senator Tillis, and Senator Graham. So I think this is a proud day for the committee, and I believe that the 14-7 vote sends a clear message that not everyone agreed on this, but a clear message that we must protect this investigation and investigations going forward, as Senator Tillis so well noted, that this is not just about this investigation, it's really about all investigations going forward. For me, this issue has really hit hard as a former prosecutor, and I spent 8 years doing that job, and we would have cases come before us all the time where maybe the victim wasn't very sympathetic, or maybe you knew the defendant, or it was some kind of white-collar case of someone that people liked in the community, and you would always have to see your job as being a minister of justice, that your job was to convict the guilty and to protect the innocent, that you had to do your job without fear or favor. And so that's why my blood boils when I hear some of the comments from people either on TV or threats of firing people, that you have to follow the law wherever it leads you. And that doesn't mean that you don't have discretion sometimes to be compassionate about how you follow the law. But the law here is clear. The intent of the Justice Department rules are clear when they say that you cannot fire someone except for good cause. And what this bill simply does is takes that concept and makes it clear that you just can't run all over our rule of law. And that's how I see it, in a very simple, straightforward way. So I just want to thank you again. I hope this does get to the floor. I hope that the leader will listen not just to the wisdom of this committee, but also to the wisdom of the American people. Allow this investigation and future investigations to be completed without political interference. Thank you, Mr.
Senator
Chairman.
Coons.
Thank you, Chairman Grassley. I just want to begin by thanking you and your staff, Ranking Member Feinstein and her staff, Senator Booker, my great partner in crafting this legislation, and Senator Tillis and Senator Graham. This is what the Senate should be, an opportunity to work together to close differences that we and our staff had, to craft a significant amendment that showed your ongoing dedication to transparency and oversight, Mr. Chairman, and to get to a positive result. I want to specifically thank Erica Songer and Andy Crawford in my office, who worked very hard with staff in other offices for their dedication to getting us to this point. I have lengthy arguments, which I will submit for the record, about the constitutionality. As my friend and colleague, Senator Booker, pointed out, Morrison v. Olson remains good law by 7-1, a wide range of members of the Supreme Court, from Justice Brennan to Justice Rehnquist, rendered this opinion. As I mentioned previously, it's been cited by dozens of courts in the 3 decades it's been on the books, most recently by the D.C. Circuit in an en banc opinion. There are plenty of good cause restrictions in the executive branch. The President has never had an unfettered, unrestricted authority over law enforcement in the history of our democracy. I will just briefly quote, if I could, University of Chicago law professor Posner. The founders did not give the President the power to determine the necessary offices and positions within law enforcement. They gave Congress the power to define those offices. The founders did not give the President budgetary control over law enforcement. That power went to Congress. The Constitution recognizes the grand jury, which has executive power, yet is not under the control of the President. There are many different sources I could cite showing that the weight of authority supports the constitutionality of this bill. I think it is important that we proceeded with the bill once convinced of its constitutionality, and I'll submit for the record letters from elected Republicans, former federal judges, prosecutors appointed by Republicans, and a series of constitutional law professors. Why is that important? Because a question was raised in today's debate about whether we were proceeding rooted in confidence that this bill would withstand constitutional muster. I have that confidence. I think it was also important that Republicans and Democrats today reasserted that whether agreeing with this bill or not, we all have a view that Special Counsel Mueller should be able to conclude his investigation without harassment or interference. I also think it's important, as Senator Tillis has said from the very beginning, that this isn't just about this circumstance, this context, this president. This is about the independence of the Department of Justice, our respect for the rule of law. I'll close by saying this. This is much more than about one person or one president. It's about ensuring that no one man or woman in our system is above the law. James Madison said, "If men were angels, no government would be necessary. Power must never be trusted without a check." This is a critical check, and I am grateful to you, Mr. Chairman, the ranking member, to my good friend Senator Booker, and to our colleagues, Senators Tillis and Graham, and our staff for crafting this, for getting it to this point, and I look forward to working with you in a bipartisan fashion to ensure it gets the hearing and the vote on the floor it deserves. Thank you.
Your inserts without objection will be included. Senator Booker.
Chairman, you are already considered a man of Solomonic wisdom. Now I know you have the patience of Job as well to wait through all of the rhetoric of your colleagues. So thank you very much for your leadership. I literally just waited this long just to give gratitude one more time. I did not get a chance to publicly thank Senator Feinstein. I know she's no longer here, but I just wanted to heap upon her my gratitude as well. Her and her staff were angelic in terms of their guidance, their stewardship, their wisdom. They're making sure we got to this process, and I wanted to make sure that was on their record. I wanted to reiterate my just gratitude to staff. You know this yourself, sir, that these are tremendous agents of change. There were moments that these things were being negotiated, that they were the ones carrying this in many ways forward at many points of this process. And I just want to give thanks to your staff, Senator Feinstein's staff, and the 4 principal staffs as well. And then finally, I just want to say, Chairman, you and I've only had a few years to serve with you, sir, and only a few months to serve with you on this committee. But this, to me, watching your leadership from our experiences in the last Congress, working on criminal justice reform together, to my experiences here, to even our partnerships on issues like tax credits for wind, you have shown statesman-like leadership at a time that we really, really need it. I watched yesterday where Johnny Isakson, someone who Senator Coons and I have a tremendous, not just respect for, but love for, and Senator Tester partnered together and showed that partisan politics needs to be always subordinate to what's in the best interest of this country. That is a spirit that reaffirms my faith in this institution. You are a chairman from another party that often has done the same, and for that I want to end my long litany of gratitude with one more time thanking you for your stewardship and your leadership. It's been an honor in these few months to be a junior member of your committee. Thank you, sir.
Thank you. Committee meeting adjourned.